Hello and welcome back to Elise Explains IP, the podcast where we unpack the intellectual property issues that actually matter for businesses. Because intellectual property isn't just about filing trademarks or registering designs. It's about how your brand is used, controlled, and protected in the real world. And increasingly, that real world is social media. Instagram, TikTok, LinkedIn, YouTube. These platforms are now where brands are built, promoted and talked about. But they also create a range of IP risks that many businesses don't think about until something goes wrong. Today we're talking about social media IP risks for brands. This includes inconsistent use of your brand by marketing teams or influencers, influencer behaviour damaging your brand reputation, loss of control over brand assets, and the legal risks around user-generated content and reposting. And importantly, we'll talk about how businesses can manage these risks before they become expensive problems. Traditionally, businesses had tight control over how their brand appeared. Your logo appeared on packaging, on your website, advertising campaigns, television ads, and maybe some printed materials. Everyone remembers newspapers, right? Everything was usually reviewed and approved internally. Social media is completely different. Now, brand content may be created by marketing staff, social media managers, external agencies, influencers, brand ambassadors, and sometimes even customers. And all of these people may be using your brand assets slightly different. Logos get stretched. Trademarks get shortened. Taglines get changed. Hashtags start replacing brand names. And over time, those small inconsistencies can actually weaken your legal trademark protection. Let's go through some of these risks and see how you can mitigate them. Risk number 1, inconsistent use of the brand. One of the biggest risks on social media is inconsistent brand use. Trademarks are strongest when they are used consistently and clearly as a badge of origin for goods or services. But social media tends to encourage abbreviations, creative spelling, meme-style adaptations, and hashtags replacing the actual brand name. For example, say you were a brand called Ocean Harvest Seafood. It might end up appearing online as Ocean Harvest, one word, Ocean Harvest, 2 words, hashtag Ocean Harvest, OH Seafood, or just Harvest. From a marketing perspective, this might seem harmless. But from a trademark law perspective, this can create problems because your registered trademark may no longer match the way the brand is actually used. And this inconsistent use can weaken the distinctiveness of your trademark. And also, competitors may start using similar wording. Over time, businesses discover that the brand consumers recognize is not the brand that's legally protected. And that requires refiling or re-evaluating. Risk number 2. Influencers using the brand incorrectly. Influencers are great, but they introduce another layer of complexity. Many influencer agreements focus heavily on content deliverables, posting schedules, and payment. But what they often say very little about is how the IP is to be used, which means influencers may alter logos accidentally, use outdated branding, apply filters or overlays that obscure the mark, or combine your brand with other brands that you didn't approve of. For example, an influencer might create a reel that adds your logo in a different colour, or crops the logo, or adds text directly over the mark, particularly as captions. That might seem minor, but legally it can become problematic because it changes how the mark appears in public, and it may not qualify as proper trademark use, and it can dilute your brand consistency. This is particularly common on platforms like TikTok and Instagram, where visual style and aesthetics often take priority over brand guidelines. Risk number 3, influencer behaviour and brand reputation. Another risk isn't strictly about trademarks, but it still has major brand implications. Influencers are effectively temporary ambassadors for your brand. If an influencer behaves badly, the reputational damage can quickly flow back to the business. Examples include influencers making offensive or controversial statements, promoting competing products, engaging in misleading advertising, or becoming involved in a public scandal. Because social media moves quickly, the brand can end up associated with that behaviour almost instantly. And if the influencer is prominently displaying your logo, tag, or product in their content, the connection becomes even stronger. This is why well-structured influencer agreements may include morality clauses, termination rights, and controls over ongoing use of brand assets. Without these protections, it can be difficult to stop problematic content from continuing to circulate. But of course, we all know once it's out there, there's very little you can do to put the genie back in the bottle. Risk number 4, loss of control over brand assets. Social media encourages rapid sharing and reposting of brand content. Once brand assets are published, they can be reposted by influencers, shared by fans, copied by competitors, or turned into memes. Sometimes this is positive as it increases brand exposure. But it also means businesses can quickly lose control over how their IP is used. Everyone's made a reel or a response to a reel and spliced some content in there. Common examples include logos being extracted and reused in unofficial content, product photos appearing in unrelated advertising, and branded graphics being modified or repurposed. In some cases, competitors even borrow elements of social media branding to make their own products look associated or similar with the brand. Because social media content spreads quickly, businesses often discover these uses after the content has already been circulated widely. Risk number 5, user-generated content. Many brands actively encourage user-generated content. For example, reposting customer photos, running hashtag campaigns, or featuring customer reviews or videos. And while this can be great marketing, it also raises copyright and IP ownership issues. Just because a customer tags your brand does not necessarily mean you have the right to reuse their content commercially. Reposting without permission can sometimes lead to disputes, particularly where the photo was professionally taken, the creator expected to get credit or payment, or the image is used in advertising. A simple repost might feel informal on social media, but legally it can still involve copyright licensing issues. Risk number 6, hashtags becoming the brand. Another interesting risk is when hashtags start replacing the trademark itself. For example, a brand might encourage a campaign hashtag like hashtag glow with Aurora. Over time, consumers may start referring to the product simply as glow with Aurora rather than the registered trademark. That can create confusion about what the brand actually is, what wording is protected by the trademark, and how the mark is to be used commercially. In some cases, the hashtag version becomes more famous than the registered trademark, which creates problem if the business later wants to enforce its rights. It might require re-registering. So, what should businesses do? The good news is that these risks are manageable with the right systems in place. A few practical steps can make a significant difference. 1. Create clear social media brand guidelines. Sounds basic, but your brand guidelines should specifically address social media use, including correct logo formats, approved color variations, how the trademark should appear in captions and hashtags, or whether abbreviations are allowed. These guidelines should be shared with marketing teams, agencies, influencers, and anyone who you intend to share as a brand partner. Consistency is one of the most powerful tools for protecting trademark rights. 2. Include IP terms in influencer agreements. Influencer contracts should clearly address how the brand may be displayed, including those brand guidelines, restrictions on modifying logos or brand assets, approval processes for contents, rights to remove or require deletion of posts. It may be worth considering a morality clause, but that is sometimes problematic because they can be difficult to enforce. Number 3, monitor brand usage online. Brand owners should regularly monitor how the brand name is used in captions and hashtags, whether logos are being altered, and whether competitors are adopting similar branding styles. Early detection makes it so much easier to address potential problems. 4. Clarify rights for user-generated content. If you plan to reuse customer content, shoot them a DM, get some permission, credit the creator, or include clear terms in any campaign rules. Many brands now include simple content reuse permissions in hashtag campaigns to avoid uncertainty. What are the key takeaways? Social media is one of the most powerful branding tools that businesses have today. But it also means your brand is being used by more people in more ways and in more creative ways than ever before. Without clear guardrails, that creativity can gradually erode the legal strength of the brand itself. My key takeaway is simple. Brand protection doesn't stop at registering your trademark. It requires ongoing control over how the brand appears in the marketplace, including online. And in today's environment, that marketplace is everywhere. Thanks for listening to Elise Explains IP. If you found this episode useful, feel free to share it with a colleague or business owner who might benefit from understanding the risks around brand use online. And if there's an IP topic you would like to see covered in a future episode, I'd love to hear about it. Shoot me a message via my website. The link is in the description. So, until next time, protect what you're building, because the smartest businesses don't just build brands, they protect them. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.